In a significant development in the Bilkis Bano case, the Gujarat government has told the Supreme Court of India that it has decided to release the 11 convicts in the case on completion of their 14-year sentence as their behavior was found to be good and after approval from the central government. The government has also apprised the Supreme Court that this particular decision was taken as per the 1992 remission policy as directed by the Supreme Court and not under the circular governing grant of remission to prisoners as part of celebration of the Azadi Ka Amrit Mahotsav. The Supreme Court has further been apprised that the government has considered the opinions of 7 authorities to grant this particular remission. To provide a brief context, as India celebrated the 75th anniversary of independence on 15th August, 11 men sentenced to life imprisonment for the gang rape of Bilkis Bano and the murder of 7 of her family members, including her 3-year-old daughter, in a communal attack during the 2002 Gujarat riots, were released from jail in Govt. Bilkis was the only survivor of this heinous crime. The investigation was subsequently handed over to the CBI as per the directions of the Supreme Court. The Supreme Court had also shifted the trial to Maharashtra. In 2008, a sessions court in Mumbai passed the sentence in this particular case. As the 11 convicts walked out of prison on 15th August, they were welcomed with sweets and garlands. The Gujarat government said that it had relied on its old remission policy of 1992 to approve their applications for remission of the sentence and not the current policy of 2014. This was done after the Supreme Court in May this year, while hearing a plea by one of the convicts for premature release, had held that the Gujarat government was the appropriate government to consider the remission in this case and had directed that the remission applications be decided within a period of 2 months. The government reply filed before the Supreme Court also reveals that while the proposal for premature release of the convicts was opposed to by the Superintendent of Police (CBI), the State Crime Branch of Mumbai, as well as the Special Judge (CBI) of City Civil and Sessions Court, Greater Bombay, however, all the authorities in Gujarat gave their no objection for the release of the 10 convicts. However, the premature release of prisoner Radhesham Bhagwan Das Shah alias Lala Vakil was also objected to by SP Dahod and DM Dahod. Even the Additional Director General of Police, Prisons and Correctional Administration, Ahmedabad, did not recommend his release. These particular submissions have been made in response to the petition filed by Subhasini Ali, a member of the Communist Party of India, Marxist, journalist Revati Lal and Professor Ruprek Verma against the premature release of the convicts in the Bilkis Bano case. The government in particular has also stated that the petition is neither maintainable in law nor tenable on facts and has argued that the petitioners have no locus to challenge the remission orders. Alleging that the petition has been filed at the instance of a mere busybody, which is political machinations, the government has argued that the plea is liable to be dismissed. On the petition filed by Ali and others, the Supreme Court of India on August 25th had issued notice to the government. The Supreme Court on September 9th had also issued notice in a similar petition filed by TMC MP Mahua Moitro and others against the premature release of the 11 convicts. We have covered in detail what happened in prior hearings of this case, the link to which has been given in the description box below. Today, during the hearing of the case before the Supreme Court of India, the Supreme Court remarked that the particular counter affidavit filed in opposition to the PILs challenging the premature release of the convicts in this particular case is very bulky. During the hearing, Justice Ajay Rastogi asked, and I quote here, "A series of judgments are stated. Where is the factual scenario? Where is the application of mind?" Solicitor General of India Tushar Mehta, appearing on behalf of the government, responded that the judgments were only mentioned for easy reference and that it could have been avoided. At the very outset of the hearing today, Senior Advocate Kapil Sibal sought time to respond to the counter affidavit of the state and the convicts. Allowing such a request, the bench adjourned the hearing to November 29th. Thank you. I'm Aratrika Bhaumik for LiveLaw. Keep watching LiveLaw for more such updates.